Good evening to everybody. Welcome to the today class of the Advanced Private International Law. And today that I am going to deal the law of succession. There is conflict in law of succession under the private international law. So generally, when you are using the succession, we don't use a separate country law, but that country law could be used over there where the deceased having the domicile. For the immobile property is concerned, there is no dispute at all. But the dispute comes only to the mobile property. Yes, anyone can unmute and read what I posted on the screen? Anyone can unmute and read what I posted on the screen? Okay, let me read it. I said, good evening to the students of the Advanced Private International Law and the conflict in the law of succession under the private international law. Professor Mohammed Saheb Hussain, Professor Law, South Monza, Tanzania. And now let us, without wasting the time, that we will come to the point, law of succession, how it works. So succession and property. Let us see that succession, extrinsic validity and probate of wills. Now let us see what is the extrinsic validity of the wills is governed. Extrinsic means outside. Intrinsic means inside. So extrinsic, by the law of the country, see the country law, where the decedent is a national. Who is the decedent? Decedent is nothing but, yes, anyone? Decedent is nothing but a deceased person. A deceased person is a national. In which country he is a national? That is number one, extrinsic value, the connecting factor, expatriate. Number two, by the law of the country where the will was executed. Suppose if you are written a will and where is executed, that country law would be applied over there. Number three, by the law of the country where the decedent is a resident. And here, the law of the country where the resident is a resident, instead of resident, we can better say it is a domicile. Of course, we need not worry about the Philippines law because we worry about the Tanzanian law. Now let us see the Tanzanian law also. Then intrinsic validity of will is governed by the national law of the decedent. So when the intrinsic validity of the will is there, then what are the deceased national law would be there. But for instance, Tanzania is there. What are the law would be used for the succession? Indian Succession Act. Is it clear? Say yes. So Indian Succession Act will still we use it. Then when you come to the probate of the will is concerned, and here he has again Vida D. Perez versus Tolete and GR number 76714 June 2, 1994. So let us see that what the probate of a will. Now the facts of the will it goes in this manner. The Kunanan, C-U-N-A-N, Kunanan, spouses, formerly Filipino, but became American citizens and residents of the New York. Each executed a will also in New York. So they executed a will containing the provisions and the presumption of survivorship. So if anybody is survived over there, the will come only at that instance when the person who wrote the will is no more. Then the will validity will come out. So survivorship in case of a doubt, husband presumed to have died first. Suppose the both have died in an arson or in an accident. The presumption is that the husband is died first and the spouse survived. Later, the entire family perished in a fire that gutted their home. After that, the entire family was gutted in the fire in the home. Then Raphael is the trustee of the Kunan husband's will. So the Raphael is a person and he is a trustee of the Kunan husband's will as per the husband will, and he is a trustee and file for a separate probate proceedings for both the wills. Meanwhile, both the wills means the Kunanan spouses, means wife or husband, both will executed a will. Meanwhile, Salud Perez, the Kunanan's wife's mother, and she is another lady, Salud Perez, and she is the Kunanan's wife's mother, and wife's mother means the wife is a lady's mother, and file a petition for the reprobate of her, the New York law should govern, and which the law salute is not an heir, and here salute is not a heir because the mother, the wife's mother, is not an heir, but he and his brother and sisters are. But who? But he and his brothers. Here, he in the sense the deceased brother or deceased sisters are. For her part, Salud claimed that she was her daughter's sole heir, the daughter's sole heir she was, and that two wills were in accordance with the New York law because both the spouses has executed a will that, and here the Quran is the trustee, is a trustee of the Quran husband's will. As per the husband will, the Rafael is there. For the wife's will, the mother is there. This is salute. Of course, mother will not entitle for that one because the deceased having the children. That no. The deceased having the brothers and sisters. So now let us see that Salud claimed that she was her daughter's soul. Her daughter's sole heir, she claims, and that two wills were in accordance with the New York law before she could present the evidence to prove New York law. However, reprobate court disallowed this will. So now, if a will wants to be allowed or disallowed, now let us see that how a will probate would be there. Because in the will itself is administrator, and administrator 6 will be written over. If it is not written over there, then generally the close relatives will file a case to the collector as well as to the competent court. They will make it a probate. The probate gives that the will is a genuine or not. If the two wills are there, then the question comes, which will is considered or genuine and which is not considered. So that is the issue, is whether or not the will should be allowed. So with the genuine, it should be allowed. If it is not genuine, it will not be allowed. So that is the issue, whether the spouse side will is allowed or the husband side will is allowed. So the Supreme Court held that the petitioner should be allowed to present the evidence of reprobate of the wills, and the notice should be given to the Raphael and other heirs. Suppose the wife's will wants to be make it out that genuine, then the notice should be served to the husband side trustee, the Raphael, and the notice should be given to the Raphael and the other heirs. Those who are the other heirs should be there from the husband's side. To allow the will, prove that both the conform to the formalities prescribed by the New York laws or by the Philippine laws is imperative. But they are left it, but they made the will in the New York. At that instance, it will be the New York law would be applied generally. Evidence required are as follows. Number one, due execution of the will in accordance with the foreign laws. Okay. Number two, testator has a domicile in the foreign country and not in the Philippines. Okay. It's a domicile of the New York, and the will has been admitted to probate in such a country, that is the New York. Number four, the fact that the foreign tribunal is a probate court. Yes, foreign tribunal is a probate court, means the New York. The laws of the foreign country and procedures and allowances will. At that instance, when the will is made in the New York, then the formalities of the will should be followed. The forms of the New York, the validity of the New York, formality of the New York, and the substantial of the New York. The wills, except for the first and last requirement, the petitioner submitted all the needed evidence. The petitioner should have to submit all the needed evidence over there to reprobate. Then only it will be allowed. If not, the husband side Raphael will be allowed. The necessity of the presenting the evidence on the foreign laws upon which the probate in the foreign country is impelled by the fact that the courts cannot take the judicial notice of them. When the foreign country is there, what law should be applied, what not should be applied, that will be taken. And if it is not proved reprobate, it naturally the Raphael side will be the valid will. So that was the decision will be there. So those who wants to rebut it, he should have to prove it. If they don't prove it, then naturally as usual, the husband side trustee will be the legal trustee will be the person that will be the valid will. According to that will, the distribution of the property of the deceased will be undertaken. Now let us see the situs of the shares of stocks. If the shares are there, of the stocks are there, how it can be made it. So power of the ancillary administrator are actual citers of the shares and stock. Even shares and stocks is a mobile property. So Tayak versus Banquet Consolidated INC, let us see the facts. That Idona Slade Perkins, an American citizen, is the name. Idona Slade Perkins, an American citizen, is the name of a person. Participant, are you hearing me? And who died in a New York City? Who died in a New York City? Okay, left. What happened? And the American citizen, and left among others two stock certificates issued by the Banquet Consolidated, a corporation domiciled in the Philippines. Okay, the corporation domiciled in the Philippines, that is the one stock. As the ancillary administrator of the Perkins estate in the Philippines, Tayag now wants to take the position of those stocks. So an administrator of the Perkins state in the Philippines, Mr. Tayag was there. Now he wants to take the position of those stocks. Certificate, but County Trust Company of the New York, because that fellow is there, died in the New York. The domiciliary administrator is here in the New York, refused to part with them because both are things. Tayag is there, wants to take the position of these stocks, and in the New York, the administrator is there, and he wants to take it the stocks. And last, and ordering the banquet consulate to issue the New York State certificate representing the Perkins shares. So they noticed to surrender the state to the Philippines. The banquet consolidated appealed the order, arguing that the stock certificates are not lost as they are in existence and currently in the possession of the country's trust company of the New York. It is not lost over there. At that instance, it is still present. Hence, the trust company of New York would be there. Now, the issue comes whether the Philippine will law would be prevail to bring the stock from the New York to the Philippine, or New York law would be applicable where the stock would be distributed or made as per the New York law. The issue is whether or not the order of the lower court is a proper. Suppose the lower court which is given the decision in this regard is a proper or not. So held that the appeal lacks merit. It doesn't have the merits over there, hence the appeal is lost. The Tayag lost the appeal because Tayag is from the Philippines and the consolidated company person is from the Banquet Consolidated Appeal, and he is the actual the administrator of the Perkins estate. So the appeal was lacks merit because a person who wants to make it out, he should have to prove it. So Tag, an ancillary administrator, has the power to gain the control and position of all the assets of the decedent within the jurisdiction of the Philippines. So how it may be there? Actually, the ancillary administrator who is there in the Philippines and all assets of the decedents means deceased with the jurisdiction of the Philippines. But the deceased is the domicile of the New York at the time when he died. So all the stocks which are said to be the mobile property would be based on the domicile, the law of the domicile. So there can be more than one administration of an estate. When a person dies intestate, means without leaving the will, the owning of property in the country of his domicile, the country of the domicile as well as in a foreign country, administrations had no both the countries. So when the administrations had both the countries would be there, but the mobile property is concerned, generally the connecting factor is the lex domicile. Means the domicile of the deceased will be taken into consideration. But the domicile of the deceased died in the New York. Hence, the New York law would be applied over there, but not the Philippine law, even though he comes from the Philippines. In the country on its domicile as well as in the foreign country, administrator had in both the countries. That watch is granted in the jurisdiction of the residence, means deceased lost domicile is termed the principal administration. The principal administration here is the New York, while any other administration is termed is ancillary administration. The tag is the ancillary administration, but the primary administration is only the New York. The reason for the latter is because of the grant of administration does not expropriate vigore have any effect beyond the limit of the country in which it is granted. So any limitation would be there if anything will be made clear that will be applicable to that country only, but it will not extend it to the jurisdiction to the other country. Hence, An administrator appointed in a foreign state has no authority in the Philippines. The ancillary administrator is a proper whenever a person dies, leaving the country other than that of his lost domicile, property to be administered in the nature of the assets and deceased liable for his individual debts and to be distributed among the heirs. So, when the mobile property would be there, when the deceased died in a particular country where his domicile, in general, that country law would be applied over there. So, that is the whole gist. Let us see that probate courts has authority to issue the order enforcing the ancillary administrator's right to do the stock certificate when he actually cites and the shares of the stocks in the Philippines. If the shares are there in the Philippines, at that instance, lex situs means, of course, the stocks are mobile property. It would follow then that the authority to the probate court will require the ancillary administrator right to stock certificate covering the, of course, year 33002 shares are there in the Philippines. Standing in her name in the books or appellant backward consolidated the ANC which is there in the New York and where the Rafael is the person, is a trustee, is respected equally beyond the question because the shares of the there, the domicile of the deceased is the New York. At that instance, we cannot, the connecting factor also says the lex loci domicile, and for apparent is a Philippine corporation, and owing to the full allegiance and subject to the under restricted jurisdiction of the local courts, its shares of the stock cannot therefore be considered any wise and immune from the lawful court orders. So naturally, ancillary is the secondary one. The primary one is the more prevail over the ancillary. Our holding in the Wells Fargo Bank and Union of Collector of the Internal Revenue Funds application is another case law. In that instant case, the actual status of the shares of the stock is in the Philippines. The corporation being the domicile here, then the force of the above under undeniable proposition, not even appellant is insensible, it does not dispute it, nor could be successful to do so when you are so minded. Now the question comes over there. If the citus would be there, the clearly made in a particular country, then that country law would be applicable over there. But the stocks generally would be said to be the movable property, if I may not be mistaken, because it is like a money. And at that instance, if this property would be there, stock, okay, we can say it is a mobile property. If the shares are there, then we can say it's the mobile property, and hence we can change from one place to another place. At that instance, lex domicile would be applicable over there. The appellant Tyagi, and he could not succeed it because he could not prove the merits of the case in this case law. So that is the whole gist of the case law. But before we are making anything, first we have to know what would be the law in Tanzania regarding the wills are concerned, regarding the probates are concerned. Because there is no dispute over the immovable property. Immovable property, where it is situated over there, that country law would be applied. Where it comes to the movable property of the deceased, then if it is dies testate, if the dies intestates, at that instance, the thing will come. Then the law of the country, that is the succession law, the Indian Succession Act will be applicable over there in India with the slight modifications, and hence at that time it could be the will be executed in that way. In case if it is not made the will and the deceased dies intestate without writing the will, then the question comes over there and how the property would be distributed among the heirs if they are alive. And now the question comes over there, the nearer heirs will eclipse the far distance relatives or heirs. And that is a general principle that we will commit. When mother is alive, then mother's mother will not get any heir because mother is the nearest relative and mother is a secondary degree, and hence she will be eclipsed when the first degree is present over there. Now let us see how the law would be there in the case of the Tanzania. Okay, let us see update on the Tanzania succession law and how it can be and what it can be. So when the succession law, probate and administration of the estates law, the production of the bona fide purchaser of a probated asset in Tanzania. So number one, the introduction, when you see it, the probate and the administration of the estate act, there is a special act would be there, cap 352 defines an administrator or administrator 6 In case it is a female, female is called administratrix. Administratrix is the female, administrator is the male. To be a person appointed by the court to administer the estate of the deceased person when there is no executor or no executor is liable and willing to act. If it is not will, or if it is will is there and the executor is there, but he doesn't want to continue it and is not willing to do it at the time, the court will appoint the administrator. But the same law defines an executor to be person to whom the execution of the lost will be deceased person is. By the testators, a person who prepares a signs a will and appointment confided. Suppose if he is really appointed the administrator, but the administrator is not willing to act over there, at that instance, the other people will try to make it out, but when the dispute would be there, who will be the administrator? At that instance, the court will interfere and appoint the administrator. Therefore, the administrator of the estate is appointed by the court when there is no will or there is a will which has not appointed as an executor. That is the case. The administrator or the executor, as the case may be, is given a mandate to administer, distribute, and dispose the estate on behalf of and for the benefit of the heirs. For the benefit of the heirs, administrator will act it. Of course, he will get the remuneration. Then the honorarium will be paid over there. Once it is over, then naturally he is ceased to be administrator. A person who buys in a good faith property with an estate of the deceased being the sold by an administrator with a valid letter of the administration or the executor of the valid will, as the case may be. What means a person who buys, who in good faith a property within an estate of the deceased being the sold by an administrator. When the property was sold by the administrator and in a good faith, if a person has purchased it with a valid letter of the administration or the executor of the valid will, as the case may be, is referred to as a bona fide purchaser. Because with a good faith and bona fide faith, and if he knows that administrator will be appointed for the deceased person, and if a person has purchased such a thing, then definitely that he will call a bona fide purchaser. The term bona fide means without an intention to deceive. That is the term meaning. The bona fide purchaser is accorded protection under the law for all the purchases made in good faith. Yes, without notice of any encumbrances on the estate. If there is any encumbrances would be there. Without any encumbrances, naturally the bona fide purchaser is there, a real purchaser. In this article, the litigation team of the Breakthrough Attorney highlights the legal framework governing the protection of the bona fide purchaser to private properties in Tanzania. Yes, a bona fide purchaser is having a very right as if that is a real purchaser. So number two, power of the sale of the estate upon the administrator or executor. What are the power of the sale will be there on the estate upon the administrator or the executor? The provision of the section 101 of the Probate and Administration of Estate Act, that is the Cap 352, revised edition 2002, provides for the power of the sale of the estate, the administrator or the executor of the estate. The provision states in this manner. An executor or administrator has, in respect of the property vested in him under the section 99, power to dispose of the movable property as he thinks fit, as the powers of the sale, mortgage, leasing, and otherwise in relation to the movable property conferred by the written law upon the trustees of the trust for the sale. So, when the necessity would be there, and when there is a clearly mentioned for the benefit of the beneficiaries, and if any property will be sold, yes, it can be sold. But in certain cases, the administrator should have to take the permission of the court when he wants to dispose the property. Even furthermore against the property also. That in the other sense, he cannot act according to his whims and fancies. Who? Administrator or executor. Is it clear? Participants. Today participants are not replying. So now it is apparent from the above provisions. What is that apparent? That the administrator may sell the property of the deceased. Yes. But without any reason he could not sell it. If it is a benefit for the beneficiaries or it will benefit for the heirs, yes, it can be sold. In addition, the administrator may mortgage or lease the property as she deems fit. Yes, if it is deemed fit, the property should be mortgaged or it will be leased or released. It is for the benefit of the heirs, then he can do so. This principle was enunciated by the High Court in the case of Mohammed Hussaini versus Mayasa Mze and Muhanahawa. Yeah, Muan Hawa Mze. The TLR 225. In this case, the court ruled in inter alia upon grant of the letter of the administration, the, the grantee thereof becomes a fully mandated to deal with the state the best way he can, and especially does not need consent of each of the heirs or to dispose the property of which are under his custody at all the time of the administration. So when he wants to dispose the property at the time, he need not to take the each person consent, whose heirs consent. The reason is the sale which he could which he is doing is for the betterment of the heirs only. Otherwise, the value of the property will be lowered when they could not sell it in the prompt time. So that was the thing. So the second point, 2.1, is nullification of the appointment of the administrator or executor or the production of the purchaser of the property before nullification. So nullification of the appointment of the administrator or executor, that he will not be a nullify it, means no more he is an executor or an administrator, and a production of the purchaser of the property before nullification. If before the nullification, the production of the property would be there, but after the nullification, naturally the property he could not deliver it in proper way. So there are instances where the administrator's appointment is revoked, okay, after the sale of the property to the bona fide purchaser. In this case, the bona fide purchaser of the property transferred to him by the administrator or executor before nullification of the appointment is protected under the law, because the property is sold before the nullification of the administrator or the executor. Hence, and the purchaser who purchased the property is a bona fide purchaser, and hence it can be not be nullified, or there would not be a voidable or void contract. It may be there because it's a valid contract because it is sold before the nullification of the administrator. So breakthrough the attorneys lawyers were a part of the team which successfully appealed to the Court of Appeal of the Tanzania in Maire, Artan Smile and Zainabu Mze versus Sophia Njadi, civil appeal number 75 of the 2008, and reported, in which the court overruled the nullification of the sale of the property and upheld the production of the bona fide purchaser. The court reasoned inter alia that because the transaction took place before the nullification of the administrator, at that instance, the transaction is a valid transaction and the nullification is later happened over there. Hence, the transaction is a valid transaction. It cannot be nullified. The four heirs of the Yusuf MJ, per page 18 of the record appeal, consented to the sale of the house of 29 of the plot number 4, block 61, Livingstone Street, Kariako, Dar es Salaam, under the circumstances the administrator Rix, the female one, lawfully sold the house in dispute to the first appellant, the Mayor Atan Ismail. The latter was a bona fide purchaser for value without